Nice meeting all, a bunch of students from the same college. Feeling really nice to meet you all again. And there are a couple of students from our college interning with the firm, the AKS, and how the codes are basically taking this session, handling this code. So it would be better if it is an interactive session, if I can interact with the students. And how many of you are aware of the subject? So let me take you to the basics of this code first. So this code was introduced in the year 2016, so which came into enactment and force from 28th May 2016. And this code was basically challenged, and this was Ribbon Private Limited versus Union of India, the case where the Supreme Court upheld the constitutional validity of this code in the year 2019. So when the code came into enactment, there were certain acts which was repealed and amended. So one is the Presidency Town Insolvency Act and the Provisional Insolvency Act. And the amended acts was the Companies Act, the Surface Act, the DRT Act, and Sikh Industries Companies Act. So we'll just try and understand how and who are the people who is constituting. This is not like a basic civil case where a general public come into picture and ask for a relief of an injunction or a declaration. So this act is a specific act and a special act for certain kind of enterprises or a company or a body of people. So let's try and understand who are these people who can be part of this particular act. So this act is basically a part of a Companies Act, where in the earlier Companies Act, where the companies defaulted in the payment, approached the High Court and filed a petition for winding up of the company, where the court felt the company cannot be revived or is not able to pay its debt, used to order for a liquidation of this particular company. But this act came into picture with some features and aims to it. So in a winding up procedure, basically the company is getting into a liquidation process where it is a death of a company. So what is basically this insolvency, bankruptcy, and liquidation, what we're speaking about? So just what I want to mention it in a line or two for an understanding of you all, because most of them would have come across these terminologies, and for some of them it might be new. So insolvency is basically incapability of a person or corporation to pay their dues when it comes due payable. And what is a bankruptcy? Where when a person is formally declared incapable of paying their dues to and payable bills. And what is liquidation? Where the company's assets, where the company is basically wind up, and where the company assets has been liquidated and been distributed among the claimants. So in the process of liquidation, the company ends there. So there's a death of a company. But what is this act which has specially come up about? So there are certain features in this act where this particular code is not for the liquidation. So there are process in it. So this act aims at the revival of the company and not its death. So basically, there are certain creditors who would have given certain loans or services to the company, and on failure of the payment, these particular companies approaches the NCLT, that being a part. So we will see what are the other features of this act. What is the speciality of this particular act? So it's applicable to a corporate and a non-corporate person, and it is a very time-bound manner where this particular process has been happening. So you have 180 days for a CRP proceeding to complete. With an extension, it might take up to 270 days with the permission of the court. Until the entire process of this has to be completed within a time-bound manner. So it is not going to waste a lot of time of our litigants in this matter or the company, where most of the company ends in liquidation. So we will see as to this, how this code is being, what is the applicability, scope and structure of this code. So you have the applicability of it's applicable for corporate enterprises, LLPs, your partnership firms, and your individuals. And the scope is insolvency, liquidation, and voluntary insolvency and bankruptcy. Basically, the code has been divided into five parts and schedules, where part one is a preliminary definitions, and part two is insolvency and liquidation corporate persons. Part 3 is for insolvency resolution and bankruptcy for individuals and the partnership firms. And part 4 would be for your regulations and insolvency professional agents and information utilities. And part 5 is for your miscellaneous, and the schedules provides for amendment to be carried out in the other statutes. So next we will move on to okay, I have a next slide here. So we will see basically what is this code is aiming at. As I mentioned earlier, a CRP proceeding is a corporate insolvency resolution process. So who can initiate this? So there is a financial creditor or a operational creditor who where they are being supporting the corporate debtors in conducting the particular business. And when the corporate debtor, that is being a company, defaults in its payment, that is when this financial creditor or an operational creditor initiates a CRP proceeding against them, where I would not tell for recovery of that money, but because there are apex court judgments which says that this IBC code is not a forum or not the code where you can recover your money, but it is for the revival of the company, and where you fall under certain category of the creditors where you can basically recover your money. But the code itself is not for the purpose of recovering of the money. So who is a financial creditor? It's basically a person any person to whom a financial debt is owed, including a person to whom such debt has been legally assigned or transferred. So if a bank is lending a loan, being a secure creditor, or where you have this borrowings of money under debentures, bonds, notes, and other things, where there is a financial assistance which is being given to the corporate debtor or a company. So these people are called as the financial creditors. So this financial creditors could have even assigned their loan or transferred it to an other company or a other company. Supposedly, if there is a bank which has lended a loan, which subsequently has transferred or assigned its loan to an asset reconstruction company. So of late, you could have found all these terminologies in your newspapers where there is a lot of asset reconstruction companies which is coming up, taking the bad debts and trying to recover from the companies or the lenders. So if I have to name a few, it can be Pegasus, that is one of the biggest or one of the major asset reconstruction company in the country now. And so even in those cases, the asset reconstruction company, in case of a proper legal assignment and a transfer, can approach the court. And what is a financial debt? As I mentioned again, it can be a loans, it can be a loan stock, debentures, or bonds. And a little twist to this. So I have highlighted this explanation here. So where it is for the purpose of the subclause, an amount raised from the allottee under the real estate project shall be deemed to be amount having a commercial effect in the borrowing, and the expenses allotted and the real estate project shall have a meaning irrespective of assigning to the clause D and D, D and Z and N. So basically, why I would like to highlight this particular explanation, which was subsequently incorporated in the IBC Act. This is where the home buyers come into the picture. So who are these home buyers? So when we basically look into the day-to-day reading of your newspaper and other things, there are a lot of projects which is under the where the real estate developers have abandoned the projects, have not completed the projects on time, have not given the quality of projects and other things. And the Supreme Court, under a particular citation and this particular explanation which was given, try to bring in the home buyers under the ambit of the financial creditor, because they have been financing, though they have been purchasing the apartment, they have been financially providing certain amount of money for the project. So they have been classified. So this home buyers have been classified, or the court has tried to bring them into the ambit of a financial creditor. So it cannot be initial stages when this act is basically a lot of trial and error. It's been 2016 and it came into effect from 2000. Code started operating from 2017. And it's been a trial and error process for every one of them as to how the act has to be enforced, and the principles of laws, how where they can bring into a settled principle of laws and other things. So when these home buyers were brought into the ambit of the financial creditor, so there was a particular ratio as to how many home buyers together come up and be a part of the financial creditor. So it's basically, initially they said it was 100 home buyers who has to come together to approach the NCLT as a financial creditor. And subsequently, when it is a smaller projects, 10% of the home buyers can come together and sue a company or a company under the ambit of financial creditors. So this is one of the ongoing legal issues in India. So I would not want to go into every small aspect of definitions and this one. I just want to give you how the court is practically handling these problems and practically giving effect to this act by enforcing this act. So on next, let's move on to the operational creditors. So who is this operational creditors? A person to whom an operational debt is owed, and includes a person to whom such debt has been legally assigned or transferred. So here again, you have an assignment on a transfer. So an operational credit. So what is an operational debt? It's basically a claim in respect of a goods and services, including an employment, or a debt in respect of the payment of the dues arising under law for time being in force and payable to the central government and state government or any local authority. So an operational creditor can be an employee, can be a person who is supplying you goods, who are the vendors, or who could have provided you certain services. So when we try to understand who could be the service providers, maybe when we speak about the central government or a state government, for an example, we can take our electricity board, where the BESCOMs or whichever electricity board which is supplying certain amount of electricity to the company. Maybe it could be a factory for its day-to-day functioning, or it can be a company for a day-to-day functioning. And if there are dues based on that, even they will be considering as a operational creditor or an operational it is supposed to be considered as an operational debt, where most of the companies default even making their payments. So this goods and services especially are the services without which the company cannot be running its day-to-day activities or a proper functioning of a company. So there are judgments which says that even a landlord who has rented out a property for a company, where without the premises, the company could not have been functioning. And next, what I would want to highlight is Section 8. So that basically three important sections, or like four important sections, or your primary sections in this. I mean, all of it are important. Primary sections where we need to concentrate. My slide might not cover section 7 and 9 and 10, but these are the sections where you basically approach the court in filing your petitions. So it starts like this. So section 8 is where you issue a demand notice, where within 10 days of receipt of the demand notice, the corporate debtor has to reply to the demand notice. So this notice under section 8 is a mandatory for an operational creditor. And the code specifies certain rules or certain mandatory things which needs to be attached along with the section 8 notice. Suppose we are asking for it could be a vendor who's been supplying day to day, who could be supplying certain goods to the company, and he raises certain invoices, and there's a default or non-payment of this invoices. So basically, this notice should contain what is the default amount and the invoices enclosed to it and the ledger reports of it. Based on these calculations, the corporate debtor can reply to the particular notice. So basically section 3(8) speaks about who's a corporate debtor, who's a person who owns debt to a company, to any person basically. And section 7 is specifically with respect to the financial creditors. So when there is a default or when there is a debt, which is an undisputed debt. So what is an undisputed debt basically? The debt has to be an admitted debt. The quantum of it can be disputed, but there should not be any pre-existing dispute with respect to this debt. There cannot be any arbitration proceeding or original suit or any cases which is being pending on this particular amount which are being claiming. Suppose there is a particular amount which are being claiming as to 1 crore. You could not have already initiated an arbitration proceeding, and when this particular claim is a subject matter of an original suit, maybe by the way of recovery suit, or before the arbitration proceeding for a recovery of this particular money, you cannot be approaching NCLT again. So this code basically bars any pre-existing disputes on a particular claim or a debt. So just getting back to our section 7. So section 7 is an application or a provision under which a financial creditor can be approaching the court and filing its petition. And then it comes to section 9, where an operational creditor files a petition. And then we have another section of section 10, which is for the voluntary insolvency of the company, where the company itself files a petition before the tribunal. So basically, there is a tribunal which is being constituted, which is called as a National Company Tribunal, where there are National Company Law Tribunal, where there's a technical member, and it's a bench of 2 people. It's a quorum of 2 people, where you have a technical member and a judicial member, where most of the cases where the technicality is being involved in it, such as maybe your taxes, your most of it's this company is involved in the commerce. So you need a technical member who is a part of a quorum and a legal person for an adjudicating of the matters. So they are called as the adjudicating authorities. And then we have the so once you get an order from the NCLT, there's an appellate tribunal, that is NCLAT, which is the appellate tribunal, and then where you can challenge the orders of the NCLT before the appellate tribunal, and then it goes to the Supreme Court. So next we have is the pecuniary jurisdiction. So on enactment of this code, the pecuniary jurisdiction was just 1 lakh. So every case, every act has their own pecuniary jurisdiction. So for example, in a civil court, with a pecuniary jurisdiction for a recovery or any other case, below the amount of 10 lakhs go to the small causes court, and subsequently it goes to the rural court, and subsequently it goes to the city civil judge. In the same manner here, the pecuniary jurisdiction and the enactment was 1 lakh and above. And during the pandemic, there was an amendment which was brought into the act where they have increased the threshold to 1 crore and above. And the courts are very specific in telling that the interest amount cannot be added to the principal amount and make a threshold as 1 crore. So suppose the principal amount is 80 lakhs and we cannot be adding in the 20 lakhs of interest, bring it about to 1 crore and approaching the court on a pecuniary jurisdiction. The courts are very clear in their findings where it tells the principal amount without including the interest, the threshold level has to be 1 crore. And we have a territorial jurisdiction, that is where the corporate debtor's office is registered. So wherever the registered office of a corporate debtor is, that would be the place of jurisdiction, the territorial jurisdiction. And when we next we come to the limitation aspect. When the code was enacted, the court till now has not specified any limitation. So any cause of action arises or anything for a suit to be filed or a case to be initiated, we basically need to have certain limitation. It cannot be like anytime anybody can approach the court and be filing the cases. So the limitation, so there is a landmark judgment called as the BK Educational Services Private Limited versus Gupta Associates, where the Supreme Court held that Article 137 of the Limitation Act will be attracted in this particular code. That's the IBC code. So what is Article 137? Where any other application for no period is a period of limitation is provided elsewhere. So the time has been considered where a particular act or a code, supposedly even the IBC code, where it is not providing any limitation period. So you go back to Article 137 of the Limitation Act, and then there the time period is limited as 3 years. And from when the time period begins to run is when the right to apply occurs. Maybe from the date of default, within 3 years, you have to approach the NCLT to get a relief. So next, let's see how this procedure is before the NCLT. This is not like a regular civil suits where you have it's basically a summary proceeding where you do not encourage any evidence or cross examinations like your civil suits or like your civil courts function. So basically, this is more to do like a scheme of work. So there is a default. So the financial creditor or an operational creditor approaches the NCLT on an admission of this particular petition, and there is an appointment of an interim resolution professional. On this particular interim resolution professional has been appointed, there is a moratorium under Section 14. So what is a moratorium basically? So a moratorium is where it's a sort of a stay. There could be a lot of suits against a particular corporate debtor, which is pending before the various courts. Basically, this act has an overriding effect on all other acts, including your CPC, your SURFACE acts. It has an overriding effect. So all the so there's basically a stay in institution or continuation of any proceeding against a corporate debtor, transferring or disposition of the assets of a corporate debtor, and subsequently with the foreclosures under the SURFACE Act, and recovery of a property of the owner where it has been occupied. So everything comes to a standstill. So until this procedure has been completed, whether completed, the moratorium is in existence. So I will explain to you in the little later when the moratorium will be ceased. So once the moratorium period and once the starts and once there's an appointment of an interim resolution professional, there is a collation of claims. So what happens? You there is a paper publication which is being given within 7 days of the interim resolution professional is being appointed. So basically, this interim resolution professionals are the chartered accountants or a company secretariat, where they are into the panel of this IBBI, and where they have been appointed by the NCLT, where the interim resolution profession sends out a public notice telling public notice in the regional newspaper as well as a national newspaper, stating that this particular company is under the CIRP proceeding and the application has been admitted. And anybody having claims against this particular company can submit their claims within 30 days. So what happens on this paper publication is being published. All the claims, all the claimants can file their claims before the IRP. So the IRP collects all the claims and looks into the validity of the claim and how genuine the claims are to be awarded or not awarded. And then the IRP forms a committee called as COC, that is Committee of Creditors. So this Committee of Creditors are very important because the role of the NCLT is very limited until the COC is being formed. So once the COC is being formed, all the decisions of the company will be taken by the COC. And this particular applications being or the petition being admitted by the NCLT, the board of directors stands suspended. So the IRP takes over the company, runs into the day-to-day activities of the company. So on the COC being formed by the IRP, they confirm if the same IRP would be continuing in as a resolution professional, or the COC can take a call as to if they have to replace another resolution professional of their choice. So the COC would be a committee of creditors with having a voting rights. So basically, the preferences are given to the financial creditors will form the part of COC. In absence of a financial creditors, the next level goes to the operational creditors, where they go up and file form a COC. So the financial creditors can be the banks. According to the money which has been lent to the committee, they would be having lent to the company, they will be having a voting rights, where all the decisions of the company next will be taken by the COC. So next we have the resolution professional on formation of a COC prepares an information memorandum. So this information memorandum is like a complete information of the company. So it is basically what are the debts with the company. It cannot be a debt which has been it's a collaboration of all the debts, and then what are the assets of the companies and how the company is functioning or performing. So you find a memorandum, information memorandum. On an information memorandum is being placed before the court, and within a time limit of 90 days, the RP has to issue a paper publication for revival of the company or for the applicants who would like to submit their resolution plan. So what is this resolution plan basically? So there is a company, as I said earlier, this act or this code is not in favor of liquidation or where it gets to the end of the company or the death. That will be the last thing what the act or the code's aim is. So this resolution plan is basically anybody can be submitting a resolution plan. Of course, there is a particular criteria which the rules have been framed as to who can submit a resolution plan. So basically, this resolution plan is where the resolution applicant analyzes the basic conduct of the company and tries to come up with the action plan, where if the debt is of 100 crores and the company has a project which is if it is a real estate company which is standstill and where the company can generate around 150 crores and where they can actually repay the debt, maybe the company or the corporate debtor at this juncture would not have the money for it. So this particular resolution applicant can submit a action plan as to how he can revive the company, pay back his debt, pay back all the claimant's debt in a particular way, in a particular time, and then revive the company. If the COC is satisfied with it, then the COC approves the resolution plan. Once the COC is approved the resolution plan, it has been placed before the NCLT, where the NCLT looks only into the technicalities of it and approves the plan. In case the NCLT or the COC is not satisfied, basically if the plan is not practically possible to be implemented, then the court orders for liquidation process, and the liquidation process starts. That is basically liquidating all the assets of the company and then distributing among the claimants. And next we will see what are the, so here again, I come back to the moratorium. So basically when does the moratorium stops? It's only on the completion of the CRP proceeding or when the resolution plan has been approved by the NCLT during the CRP process, the moratorium stops. So everything will go back to its normal condition. Here I would want to point out the rights of the promoters. So where is the promoters go? So there is a promoter who's a director of a company, who's a founder of a company, who has started the company, where his company is getting liquidated or a resolution plan has been approved. So what are his rights or roles when it is his own company? So basically, if the promoters are aggrieved by the order of the NCLT in the instance or in the starting itself, that is when section 7 or section 9 has been allowed or admitted, the promoters have the right to challenge a particular order before the company, National Company Appellate Tribunal with a limitation of 30 days. And any order aggrieved by that subsequently can also be approached Supreme Court within 45 days. And what is his role when the resolution plan, when the RP calls for a resolution plan for basically reviving the company? So basically, if the promoters are not subject to section 29A of the code, or there are certain criteria which has been mentioned in the act, where a resolution applicant has to fulfill all these criteria, can, as a promoter, submit his resolution plan, and if the COC is satisfied with it, the COC can approve it. So the section 29 is basically a willful defaulter. So if the banks or basically the banks would basically denote a company has a willful defaulter, that is, even if he is capable of paying, he is being with a malified intention avoiding it. So under these circumstances, if he is being declared as a willful defaulter, as per section 29A, the promoters cannot be filing their resolution plan or cannot get the resolution plan approved in their favor. However, this promoters will be an invitee to the COC, that's the Committee of Creditors, without any voting rights, and obviously will be part of the resolution process which is being happening throughout, where he can give his inputs, clarifications to the COC. And so we have the roles, we have certain roles of a resolution professional. The resolution professional basically has a huge role, because the role of the court stops when the application is being, or rather I would say it has a limited role until the application or the petition is being admitted. The RP takes over the company, looks into the management of the affairs, but obviously every 30 days, this entire process or the scheme is being monitored by the tribunal. where the resolution professionals or the liquidators keep in timely manner submitting their reports before the tribunal for their consideration, and any decisions to be taken have to be approved by the NCLT, where the case is being pending and you file your applications and seek permissions, which is uh, which doesn't comes under his powers. So what is the role of a resolution professional basically? So once the petition has been admitted and the board has been suspended, so the management and the affairs of the corporate debtor shall vest in the IRP or the RP. So he looks into the day-to-day management and affairs of it, and and try to collect and try to administer the company, and try to keep the function company alive until any decision is being taken with respect to the resolution plan or the liquidation process. And subsequently, when we come across so on a failure of a resolution plan or on a non-approval of a resolution plan, the company gets into the liquidation. Either if there are no resolution plans at all which is being submitted by any of the applicants, or on lapse of 270 days of the CRP proceedings, since these are all time mannered proceedings, the company gets into the liquidation. So when the company gets into the liquidation, the RP, in certain cases, the RP itself has been appointed as a liquidator, or depends on the COC who would want to bring in a new liquidator or an appointment. So there's an appointment of a liquidator, there is a formation of liquidation estate, consolidation of claims, and the verification of claims, and then the liquidator can admit or reject the claim, determine the value of it, and appeal by a creditor of NCLT within 14 days in rejection of a claim. So suppose if there is a claimant who has submitted the claim and which has been rejected, because the RP or for the liquidator would look into the company records, they will not be blindly granting or approving any claims. They will look into the claims as to whether the company was basically the liquidator or the RP steps into the shoes of the company and starts operating the company. So when there is no proper claim being made, or the company is not liable to be making that particular claim, the RP or the liquidator can reject it. On rejection of the claims, the claimant has 14 days to approach the NCLT. And so the liquidator, so this is another topic, a huge topic, as to what is a preferential and undervalued transactions. So basically, if on the operation of the company or on the auditing of the company, if the liquidator or the RP feels that there was some preferential transactions or an undervalued transaction which is being conducted in the company, can file a petition or an application against the promoters. So you have something called as a look back period, that is for 2 years from the taking over of the company or admission of the company. The RP or the liquidator goes back to the audits and the financial statements of for a period of 2 years, that is prior to it, and see if there was any preferential or undervalued. So what is a preferential transaction basically? So preferential transaction is where you have given preferences to certain people. So if there is a mother company, you have a sister company. So this mother company would have, so if at all, if the mother company is into supply of goods, certain goods or services, it has a sister company where it gives certain preferences to that, which is against the policy of the company, where certain transaction has been identified or are undervalued. Suppose if there is a mother company who owns a office space, who is rented out to the sister concern or any other related party to it, to the company. Maybe if the square feet or if the rent value is about 1 lakh, and it has undervalued it and rented out the premises for maybe a 60,000. So this 40,000 will be where it has been undervalued, which brings to the loss of the mother company. So these aspects of it has been identified by the RP or the liquidator can approach the court and file a petitions for recovery of this monies from the promoters. And then you have distribution of assets, where under a liquidation process, where the assets have been liquidated, basically sold out, and these monies which has been accumulated as a waterfall will be distributed among the claimants, where you have the secured creditors, the unsecured creditors, the statutory creditors, where it will be distributed among them depending on the amount of assets which is being there with the company. And I think I have fairly covered how the court is looking into this particular aspect of the companies and how they're trying to revive this company. And to be so this is just a basic understanding or maybe a skeleton as to how the company or how this code has been operating and what are the views of the court and how the court is actually being implementing this scheme. It is to do more with revival of a company, and it is not like our earlier act where we straight away go for the liquidation or winding up of a company, where this act basically aims at the revival of the company. So on a practical basis, this is one of the subject or the laws or the practice which has a rapid growth, where most of the companies are subject to the insolvency proceedings, be it your commercial transactions or be it the recovery forums, the earlier recovery forums like a debt recovery tribunals where the banks were involved, or opting this particular code because it's timely in manner and it is more effective. So for you all to even choose a career, this would be this particular act or this particular practice is not like a traditional way of practice in civil courts, which takes you years together in winding up of a case or winding up of a, or to get benefited out of this act. And this is a very advanced practice where in most of the metropolitan cities, which is where the students or where the advocates choose this as a mode of, not a mode of practice, at least the area of practice, where there are certain specific advocates who are specialized in particular act and has been doing really good in this particular subject. So if this subject is not being part of the university, because many of the universities has made it as one of the subject in their academics, so it is one of the major or a growth subject which has very good opportunities for the youngsters to explore this particular matter, and the stakes are also pretty high because the companies involved are into crores. So it's a very good exposure for the students who's taking up internships in firms and other places to at least have a basic understanding as to how this particular code is being functioned. So with this note, I think I'll end my session. And if there are any clarifications.
Thank you, ma'am, for the insightful talk. The Insolvency and Bankruptcy Code is no more alien to us.
Yeah, thank you. Thank you for giving me an opportunity to address this session. I hope awesome. It was helpful for all of you all and not wasted the time.
We now move on to the question and answer session. Participants can drop in any queries using the chat box. We have one question from Isha Pandey.
Yeah.
It says, what are the challenges in the application of the Insolvency and Bankruptcy Code?
So when it comes to the part of liquidation, though we keep repeatedly telling it is a time-bounded manner proceeding which is being happening, the major challenge in this is when the company is getting revived, we do not have much of challenges because of the resolution plan and other things. But when the company is getting into the liquidation, though the liquidation proceeding is also a time-bounded manner which is to be done, the entire procedure into like 330 days and odd, there's a lot of challenges where faced by the liquidator to liquidate the properties. I mean, to liquidate the assets of the company. That's one of the major challenges what the liquidators are being facing. And the other, I would not tell it as a challenge. The other, disadvantage of it is you have a criteria of creditors who's coming, or the claimants who are coming before the RP with their claims. When there is a distribution of the claims or the resolution plan is being approved, the plan can ignore certain creditors. Maybe the operational creditors can be ignored at a larger extent, because the financial creditors are the one who's sitting in the COC and who's approving the resolution plan. So some people are being benefited, and most of the operational creditors are not being paid or not being getting the the claims which they have been asked. So on approval of the resolution plan, all their claims gets lapsed. So they do not have another forum to go and actually recover their particular claims. So there is this part of which is being ignored. But the courts have come up and told, if all the claims can be entertained, no one will come forward for the resolution as an applicant to revive the company. So it is for the benefit of the company. There is certain schemes which is being coming up. So the next is.
Thank you, ma'am. We also have another question from Adarsh. It says the Insolvency and Bankruptcy Code as well as the Insolvency Act are directed towards the recovery of bad debt. Could you please tell us the major difference or the interplay between them?
Okay. So the Insolvency Act, who can go under the Insolvency Act? Not everybody can go. So the first point is, as per section 238, the IBC Act has an overriding effect over the Insolvency Act. So even the proceedings before the Insolvency Act is being stalled when the moratorium is being instituted or comes into force. And the Insolvency Act basically is where the banks, it's only for the financial creditor. Only the banks approach the DRT against the lenders to get their money back. It's not like any lender or any individual can approach. So IBC, and basically IBC repeatedly we have been telling, is not a recovery forum. It is only for the revival of a company. So the debt recovery forum is purely for recovery under the Insolvency Act. What we have the DRT, the Debt Recovery Tribunal, is purely for recovery of money, and IBC code is for the revival of the company, and it's not a recovery forum.
Thank you, ma'am. Thank you, participants, for engaging in a fruitful discussion.